Right, a very good afternoon, East Africa. I hope you're keeping safe wherever you're joining us from. My name is Gabriela Chaye, and welcome to the month of June. June promises to be a very fantastic month, and what better way to kick us off this month than have a discussion on sexual and reproductive health and rights in East Africa? And today we'll be exploring legal frameworks and reforms. And this session is hosted by the East African Law Society in partnership with our esteemed partners, the Center for Reproductive Rights. And this afternoon, we are profoundly honored and really exceedingly humbled to have a very stellar composition of panelists from across Africa. The session shall be moderated by Miss Prudence Mutiso, a Kenyan human rights lawyer and a senior legal advisor for Africa at the Center for Reproductive Health Rights. Prudence leads legal advocacy, including strategic litigation on reproductive rights in Kenya, Uganda, Malawi, and other countries within the region. Her work has shaped landmark jurisprudence on access to safe abortion, maternal health, and adolescent sexual and reproductive health and rights, and has contributed to regional precedent before the African Committee of Experts on the Rights and Welfare of the Child. Prudence holds a Master of Laws in International Legal Studies with distinction from Georgetown University Law Center, where she was a 2017-2018 Leadership and Advocacy for Women in Africa Fellow. With over a decade of experience working at the intersection of law, lived realities, and feminist legal practice, she brings grounded and strategic lens to this discussion this afternoon. Prudence, we are really humbled to have you moderate this session, and we look forward to having an exciting conversation. At this juncture, I will hand it over to you to take it on for the panel discussion. But while you do so, ladies and gentlemen on the call, I would like to encourage you to share the link with a colleague who would like to join the session. Please note that we'll be streaming the session on YouTube at East Africa Law Society. And also you can follow this session using the Zoom platform. We hope that it shall be engaging and we're excited to learn. Over to you, Prudence.
Thank you so much, Gabriel. Really excited to moderate this panel this afternoon. And a warm welcome to our esteemed colleagues and our esteemed participants as well to this particular session today. And as you have said, Gabriel, we're going to be looking at sexual reproductive health and rights as a human right, not only in Africa, but across the world. And as you rightly pointed out, sexual reproductive health rights is an emerging issue across the world. And this is a timely conversation, seeing that Africa is one of the continents with the highest maternal mortality rates across the world. When you look at Nigeria, for example, Nigeria has a maternal mortality of about 1,000 deaths. Going back to South Sudan, same rates of high maternal mortality rates. And so this is a timely conversation where we get to explore why sexual reproductive health and rights should be a fundamental human right. Again, when you look at the adolescent population across Africa, Africa has one of the highest adolescent populations in the world. Kenya has about 24% of adolescents, and that's when you look at other countries across East Africa, across the region as well, leading in high population of adolescents. And so this afternoon, I'm excited to have a couple of panelists who are distinguished in their field, as well as experts in sexual reproductive health and rights. And I would like to first introduce Dr. Tom Lisa, and if you may, You can choose to put your video on, Dr. Mulisa. And Dr. Mulisa is a lecturer of constitutional law, human rights, and governance at the School of Law of the University of Rwanda. He holds a Master's in Law in Human Rights and Democratization in Africa from the Center of Human Rights of the University of Pretoria, and a PhD in Comparative Constitutional Law from Uppsala University in Sweden. Is also the founder and executive director of the Great Lakes Initiative for Human Rights and Development that does public interest litigation, advocacy, and human rights monitoring in Rwanda. He is a member of the steering committee of SOAS and East Africa Interim Advisory Committee for Global Fund for Women, and is published widely on human rights, women and health, governance, and constitutional law. Welcome, Dr. Mulisa. Next, as our panelists, we have Ms. Prima Kwagala. Ms. Prima from Uganda is a human rights lawyer, chairperson emeritus of the Female Lawyers of the Uganda Law Society 2019 to 2022, and the founding and serving executive director of Women's Pro Bono Initiative, which is an organization whose vision is a Uganda free of violence and discrimination against women and girls. WPI works to achieve their vision through legal representation of vulnerable women and girls, suffering discrimination, legal empowerment, research, and knowledge. In June 2022, Prima was awarded the EU Human Rights Defenders Award, and in January of 2020, Prima was named Peace and Reconciliation Laureate by the French and German embassies to Uganda in honor of our work defending women against violence. And so welcome to this convening, Prima. Next, I'd like to introduce Dr. Godfrey Dalitso Kagaunde, joining all the way from Malawi. Dr. Godfrey is the founding executive director of Nyale Institute. He holds a Doctorate of Law from the University of Pretoria, and he's an expert on sexual and reproductive health and rights. Dr. Kagaunde's activism and scholarly interests focus on sexual and reproductive justice, particularly in the intersection of human rights and social norms in adolescent sexual and reproductive health and well-being. In September of 2023, he facilitated the filing of a public interest case in the High Court of Malawi, in which a 14-year-old rape survivor who became pregnant was sought to be protected under the Gender Equality Act and other relevant laws in Malawi. Dr. Kagaunde has published several peer-reviewed articles and book chapters on sexual and reproductive health and rights, including integrating child rights standards in contraceptive and abortion care for minors in Africa. Welcome, Dr. Kagaunde. Next on the list, we have Ms. Rosemary Kirui. And Ms. Rosemary Kirui is an advocate of the High Court of Kenya, holding a Bachelor of Laws degree from Moi University and a postgraduate diploma in law from the Kenya School of Law. She's also a certified mediator with the Mediation Training Institute, MTI, and an arbitrator with the Chartered Institute of Arbitrators. Rosemary currently serves as a legal advisor for Africa at the Center for Reproductive Rights based in Nairobi, Kenya. In her role, she uses the power of law to advance reproductive rights as fundamental human rights and supports litigation and legal advocacy efforts across 7 countries in Africa. Next on the list, I'd like to introduce Ms. Hortense Minishi. Hortense is an advocate of the High Court of Kenya and the Deputy Executive Director and Head of Programs of KELING. And so welcome to the panel, Ms. Hortense. We are so glad to have you. And last but not least, a warm welcome to Dr. Abiola Akiode Afolabi, a senior lecturer, Department of Public Law, University of Lagos, and the founding director of Women's Advocate Research and Documentation Center, WADC, based in Nigeria. Dr. Abiola is also the Secretary, West Africa Center for Law and Religion Society, a former student leader and dedicated human rights defender with specialization in gender governance, climate justice, peace, security, and international human rights law. In recognition of our commitment and efforts on behalf of our fellow citizens, the International League for Human Rights named her recipient of the 1999 Defenders Day Awards. Dr. Abiola is a full award winner, and in 2022, she received the Wole Soyinka Nobel Laureate Human Rights Defenders Award. And so a warm welcome to all our panelists, and we are so glad to have you. Before we kick off the discussion today, one of the expected outcomes for this discussion is an increased understanding of SRHR as a human right among the East African community stakeholders. And since we are joined by numerous bar association and reproductive rights advocates, we hope this particular webinar will enhance knowledge of legal frameworks and advocacy strategies to advance SRHR, seeing that we're going to be hearing from advocates with various strengths and from various countries who have lived experience litigating and advocating for sexual reproductive health and rights. And for this discussion, I'd like to kick off with Dr. Mulisa, the Executive Director of GLEAD Rwanda. And Dr. Mulisa, being a lawyer, a practitioner, a scholar as well, perhaps you can speak to us on your work in Rwanda and how you integrate frameworks, legal frameworks in SRHR as human rights in national discourse. Dr. Mulisa?
Yes, thank you very much. And I thank also my fellow panelists. I hope you can hear me well. Can you hear me?
Loud and clear, Dr. Mulisa. Please proceed. Thank you.
I hope you can hear me well, yeah.
Yes.
Yes, I think Rwanda is on the progress of developing a clear legal framework. As most African countries, we've had laws that have not been favorable for SHR with the previous post-colonial laws. But I think the reforms from 2009 and 2015 have laid the ground for what we can call at least a flexible legal framework as per now for SHR. Our recent constitutional revision, the revision of the constitution, now provides for the right to health. Explicitly, because previously it was the government has the right to health and individuals have an obligation. But now it has an explicit right to health among the few provisions in the constitutions in Africa with an explicit right to health. That is one. And I think that has been positive. Secondly, with the new penal code that removed the court order for abortion, I think that was part also of incorporating sexual reproductive health rights within the penal code. The penal code has quite a number of provisions, including crimes of if someone denies someone access to contraceptives, that would be a crime under the penal code. Failure to or denying someone such a right, it has been also provided in the penal code, and also less restrictions on safe abortion, especially removing the court order. But I think the most important part is the ministerial order on abortion that defines the right to health. The right to health is defined more broadly, including the WHO scope of right to health, not only being absence of sickness, but also mental, physical, mental, as defined by the WHO. And we have also a sexual reproductive health law. Of course, it's being reviewed now. We are with a coalition of civil society organizations that are working on the revision of the sexual reproductive health law of 2016, because previously it only allowed access to sexual reproductive health services for those for people above 18 years. But yet, with the recent trends, we can see that even those 15, 16, and 17 need to access contraceptives. So with the new proposal from the Minister of Health, the bill is in Parliament. We worked around it. We shall talk about it next time. But I think the bill proposes that sexual reproductive health services and information could be accessed by someone from the age of 15, which I think is a positive step. And we have also a national strategic plan for sexual reproductive rights, national health strategic plan, which is quite good, and also an adolescent family planning and adolescent strategic plan in place. Last month, we developed also a human rights national action plan, which also include access to sexual reproductive health services, and not mentioning the international conventions that Rwanda has signed, like the Convention on Elimination of Discrimination Against Women, and Rwanda is reporting on the Maputo Protocol that Rwanda is reporting this year. I think briefly, those are some of the frameworks, national and international, existing in Rwanda that regulate sexual reproductive health rights. Thank you.
Thank you so much, Dr. Mulisa. And I want to throw a question to you, Dr. Mulisa. Being a teacher of the law, could you break sexual reproductive health and rights to our esteemed audience so that they can have an understanding? When you talk about sexual reproductive health and rights, what does it constitute?
Yes, thank you very much. I think when we talk about sexual reproductive health rights, we shouldn't be looking at the right that is standing on its own, a standalone right. Because in most of the provisions and most constitutions and most legal dispositions in most countries, you don't have a provision in the law that this is the right to sexual reproductive rights. But sexual reproductive rights encompasses quite a number of rights. Constitutions have those rights. National health laws and policies have those rights. We are talking about the right to health, which most constitutions and policies have. We are talking about the rights to privacy. We're talking about the right to information. We are talking about freedom from torture. We are talking about the right to access to information. So when you talk about the right sexual reproductive health rights, you are talking about quite a number of rights that are enshrined in most of the domestic legislation that we have, whether privacy, whether freedom from torture and ill treatment, whether health, the right to life. So when we talk about sexual and productive right to body autonomy, so we are talking about quite a number of rights that make up the sexual reproductive health framework. Thank you.
Thank you so much, Dr. Mulisa. And now we're going to cross over to Kenya and speak to Ms. Hatens Minishi, the Deputy Executive Director of KELIN, a litigator and program lead working to advance SRHR to national courts and community partnerships. Ms. Minishi, the organization that you represent this afternoon, KELIN, has used litigation to advance SRHR in Kenya. I would like you to share with our esteemed audience some of the examples that KELIN, or rather some of the cases that KELIN has litigated on integrating the Maputo Protocol, both in litigation and in advocacy as well. Ms. Minishi?
Thank you so much, Prudence. I hope that I'm audible. So I'll speak to the aspects around regional frameworks, as well as aspects around strategic litigation and how the civil society is utilizing that as a strategy to advance and realize sexual and reproductive health rights. So the Maputo Protocol, which is also the protocol to the African Charter on People and Human Rights, is the main regional instrument that advances women's rights and specifically speaks to sexual and reproductive health rights for women. It speaks to also the aspects around eliminating discrimination, which would be found under Article 2 of the Maputo Protocol, aspects around elimination or prohibiting of harmful practices, so such as FGM, which would be found under Article 5 of that Maputo Protocol. And then the bigger aspects, the bigger rights around health and productive rights under this protocol are found under Article 14 of the protocol. And some of the rights that are envisaged under that protocol is the rights for women to control their own fertility, aspects around right to decide whether to have children, when to have children, the spacing of those children. And then there's also the right to choose the method of contraception, the right to self-protection and to be protected against sexually transmitted infections, the right to be informed of one's health status, and then the right to have family planning education. A key feature of that Maputo Protocol is it's the first regional instrument that actually recognized the right to safe and legal abortion within a legal instrument. So under Article 14.2c of the protocol, the right to access services to safe and legal abortion are listed within those rights. However, within the East African context, you would realize that some countries have ratified this protocol while others haven't ratified, while others have ratified with reservation. So this means they split enforcement of those of the provisions within the protocol. Some of the reservations, the countries that have made reservations are Kenya, particularly on that Article 14.2c, which provides access to safe and legal abortion. So Kenya, in particular, also within the national context, has provided for the right to health within its constitution. So under Article 43 of the Constitution of Kenya, we see, protection around the right to health, including reproductive health. However, and also Article 26 of the Constitution speaks to the right to life, and it allows for or permits abortion or termination of pregnancy in certain conditions when the life of the mother or the fetus is in danger. So there are specific grounds over which then this service or access to safe and legal abortion is permissible under the constitutes of our constitution. But you would find that then when you look at the constitution and then when you look at statutory laws within the country, so say the penal code in Kenya, there's a contradiction in the provisions that are provided within the protocol, the Maputo Protocol, the constitution itself, and then the statutory laws. So the penal code has provisions that speak to criminalization of procuring of an abortion, or even just giving drugs to procure an abortion. Those are instances where then this is criminalized, and we've seen instances in the past where healthcare service providers are even, imprisoned, jailed because of providing this service. So in aspects around how KELIN has utilized strategic litigation to ensure sexual and reproductive health rights, I'll begin by a case on forced sterilization, which KELIN has led on in terms of ensuring access to SRHR services and combating discrimination for persons living with HIV. So in this case in particular, there are instances where women who had been living with HIV were forced to undergo forced sterilization because they were HIV positive, and therefore we challenged that decision, and we received positive pronouncements by the court that was discriminatory and was against their rights within the regional frameworks and the rights to health specifically. We've also been utilizing strategic litigation to challenge aspects around criminalization of abortion. So that contradiction between the penal code and the constitution, how then we can utilize or harmonize these laws to come into place so that then we are not excluding women, and yet this is standards that are allowed for within the supreme law of the land, as well as regional instruments and international instruments which Kenya has ratified. Interestingly, within also the East African framework, there are aspects around the East Africa Sexual Reproductive Health Bill, which is a regional framework that, if passed, would help the East African states harmonize provisions on SRHR services and information. However, since 2017, this bill has faced significant resistance based on especially social and cultural barriers. And this mostly relates to aspects around comprehensive sexual education, as well as provisions on safe and legal abortion as well. So we are yet to see the East African member states come together to collectively and harmonize their legal and policy frameworks. But these are some of the challenges that continue to persist in limiting or creating barriers for women and also groups, other marginalized groups like LGBTI groups, to access SRHR services and information. KELIN has also been working to advance aspects around national policies that then speak to SRHR. So in Kenya, there is the National Reproductive Health Policy, and some of the restrictions within that policy, in addition to just lack of public participation for people participating to know what is within it, is aspects around third-party authorization. So where aspects like parental consent come into play, limiting access for adolescents and young people to access SRHR information and services because they are not able then to either get consent from their parents or access or have a certain age limit within which then they can access these services and information. Thank you, Prudence. I think I'll stop there and I'll be happy to take questions.
Thank you so much, Ms. Minishi, for those elaborate submissions and getting to hear, your lived experience as a litigator and a reproductive rights advocate. And indeed, when you speak about comprehensive sexuality education, Africa leads in teenage pregnancies and criminalization of adolescents. So day in, day out, whenever you go to law courts, you find, adolescents who've been arrested for engaging in consensual, non-exploitative and non-coercive sexual relations. And yet we do not want, to address the root cause of the criminalization of adolescents, which is the, the limited information on comprehensive sexuality education. So thank you so much for that. And I'm going to leave you for now as we cross over to Uganda, where we'd like to hear from Ms. Prima Kwagala, who is the Executive Director of the Women's Pro Bono Initiative and an experienced litigator with regional SRHR litigation experience before Africa regional treaty bodies. So Ms. Kwagala, you have litigated before the East African treaty bodies, and so I would like to hear more about your reflections on their responsiveness to adolescents and women SRHR, and just generally to reproductive rights, whether it's through the African Commission or the sub-regional bodies as well, such as the East African Court of Justice. And perhaps you can also speak to us about your lived reality as a counsel litigating on SRHR, and what are some of the tensions you navigate as a counsel? Ms. Prima?
Thank you, Prudence. I will briefly put my video and take it off because of network issues that I'm experiencing here. I'm afraid if I leave my video on,
All right, no worries.
So that's how I look like. My name is Prima Kwagala. I'm an advocate of the High Court and all subordinate courts in Uganda. I also have some experience doing litigation across the region. So you've asked me a question to reflect on some of the tensions that I've experienced litigating sexual reproductive health and rights. And my experience, a bit of my experience at the East African level with treaty bodies. And we've specifically engaged as an institution, the East African Court of Justice. But first, before you go to the East African Court of Justice, you must have exhausted local remedies or local court systems. My work around sexual reproductive health and rights spans almost 15 years now. Since 2010, I've been doing litigations around the right to health and sexual reproductive health and rights in particular. We did file a constitutional court case sometime in 2011, I believe. No. Yeah, of course, the research work started way back in 2010, 2009, spilling over to 2011, when we finally filed a case challenging the Ugandan government's inability to provide basic maternal health commodities in hospitals. You know, basics like mama kits. And when I say mama kits, for the men who I see mostly on the call, may not understand what a mama kit is, but a mama kit has gloves, basically, a razor or scissor. You know, when a mother gives birth, they need a razor blade to cut the umbilical cord. And for many women, especially our clients at that time, they could not afford that kit. And our government in Uganda has continuously said that health services are free. And so all you need to do is just walk. And the government's dream since the Millennium Development Goals, now Sustainable Development Goals in Uganda, was to ensure that every Ugandan within a 5-kilometer radius can access a facility. Unfortunately, it is 2025. And over the past 20 years, for so many Ugandans, that's a dream. So someone will walk 20, 30 kilometers to make it to a facility. And then when they get there, you know, the nurses will say, hey, we don't have a razor blade to cut the umbilical cord. Oh, we do not have gloves. We cannot touch you. We are putting our lives at risk or in danger. And many women were dying, needless deaths, preventable deaths for lack of professional expertise and care. That there has been some progress, and the government has been detailing that. Before 2010, I think our maternal mortality rate was at 16 women on a daily basis dying in such circumstances. So we were in the Constitutional Court, and I remember at the time the Attorney General said these were questions that raised a political question doctrine. Political question doctrine really infers that the executive has the power and the means to plan for that. So the judiciary has no place discussing what the executive is doing, more like separation of powers. So we appealed to the Supreme Court, and the Supreme Court said, no. The executive branch has been providing these things, or is expected to provide these things, and they're not. And what the appellants at the time were asking for is for the court to come and say, if you're doing this, or are expected to do this, and you're not doing that, then what is that? So the Supreme Court basically ruled away or vacated the excuse of hiding under political questions and called the court to question actions of the government. And having been successful in the Supreme Court, the case was sent back to the Constitutional Court. And I keep telling people that that process took us 7 years when we got to the Supreme Court, and coming back to the Constitutional Court another 3 years, 10 years litigating one question, whether the right to health and maternal health services is justiciable or something we can litigate about or go to court and enforce our rights. And good for us, there was a different panel of justices by the time we came back to the Constitutional Court 10 years later that indeed pronounced in our favor, you know, saying that failure to provide those basics in health facilities was a violation of right to health, sexual reproductive health and rights, and the government was compelled to put in place mechanisms. I have since left implementation of that case for several other young people to pick up. Now at the WPI, we have also been litigating access to safe abortion services. This very controversial topic, but something we've also been as far back as 2011 discussing. Say 16 women are dying due to preventable maternal mortality services in public facilities, but there are those that are aborting in communities. Why? We have on our law books outdated colonial policies preventing health workers from providing life-saving services because the law says that you cannot provide an abortion. Our constitution says that no one can take the life of an unborn child, except in exceptional circumstances. Our constitution in Uganda is a 1995 creature. We have a penal code that has been revised severally. You know, even last year we had a new set of laws, but what changes when it comes to the provision on exceptional circumstances when a health worker may be excused from providing an abortion is when in good faith, and in this case, it's a health worker who can do a surgical operation. And in Uganda, we have levels of health workers. That is not a nurse, that's not a midwife, but rather a doctor at a health center they can provide a surgical operation when in good faith they believe that this mother's life is at risk. For many women to exercise autonomy over their bodies, to say, hey, I cannot carry this pregnancy, so I need an abortion. They cannot go and have that kind of discussion. The first thing the health worker will say, I don't want to go to prison. And we have so many media reports of health workers being imprisoned for providing abortion services, even post-abortion care, which the government has unanimously agreed is a service they can provide. For sexual violence cases, our Ministry of Health has actually put out policy guidelines to say, in cases of rape, defilement, incest, you know, a safe abortion should be inferred. Unfortunately, that is not what is known publicly. Everyone knows an abortion is evil, you cannot access. When you go to health facilities, everyone will send you away, call you evil, talk to your parents, go for prayers, something like that. So in 2016, at the surge, not 2016, have been 2021, just as we were evolving out of COVID, we had so many young girls being set out of school because of pregnancy. We had a lot of discussions with the Ministry of Education. We were, you know, sharing notices of intent to sue to church-founded schools to say you must incorporate these girls. We managed to push the ministry to put out policy guidance that the girls should not be sent out of school. They should be allowed to sit exams. But even as I speak, we are currently involved in another discussion where another girl has been sent out of school because she's pregnant. So the girls were seeking, in our case, the girls were seeking abortions, but health facilities, public health facilities had refused. And for those that could, you know, outside the light of the law, access the abortions, they were doing it illegally, unfortunately, with unskilled people. And we said, no, the government needs to put in place guidance for when someone can go and get an abortion. If I have been defiled, the health workers, the technical people have said, I can access a safe abortion. So why are they not publicly publishing the exceptional standards or mechanism and measures for people to know that when I'm in this fix, I can access a safe abortion? Unfortunately, you have to wait until you're assessed. And if you're not dying, you must keep the pregnancy. So these children said, no, please help us. So we filed human rights enforcement case before the High Court in Uganda. Unfortunately, it was stayed because there were previous cases we had filed in the Constitutional Court, which again, they were filed in 2017, but had never been fixed for hearing. Even as I speak, I mean, there was a panel of justices that sat, profiled the cases, we presented the cases, they were heard. One of the judges died. I think it was Judge Kakuru at the time. Of course, the resultant effect is that the panel has to be reconstituted and the case is fixed again for hearing. The following year, we were heard. As we were being heard, I think a week after we were heard, one of the judges was promoted to the Supreme Court. Again, a panel of justices has to be formed so that the case is reheard. You know, it was reheard again, but recently again, one of them, I think, was sent to the East African Court of Justice. So case has to be reheard again. We said we cannot stay in the High Court. If you stay pending a determination of the constitutional petitions in the Constitutional Court, there will never be justice. So we decided to, on those grounds, go to the East African Court of Justice. And when we went to the East African Court of Justice, I must commend them. We put in the application, and even though there was a bit of backlog after COVID, when we put in an urgent application to be heard, because we consider this a case of urgency, the more we take long, pregnancies don't wait for your court processes. They grow and the girls have to give birth. An injustice occasion. They don't want to keep these pregnancies. Our case was, I think, fixed within 2 weeks. We had a panel. We served the Attorney General. They never show up in Uganda, but when it came to going to Arusha, there was someone from the Attorney General's office to appear. So we appeared, and the justices actually appreciated the issues. If you look at the East African Court of Justice rules and the East African Treaty, there is no specific article that makes reference to sexual reproductive health and rights. Rather, the treaty calls upon state parties to ensure that they promote gender equality. So we went under that as an issue of governance. Governance, because we were demanding that the state, the Ugandan government puts in place guidance for health workers to know when they can provide safe abortion services to women that come to them, because there is no exceptional standards spelled out in our penal code or our constitution, which says that only in exceptional circumstances can you provide an abortion. Those exceptional circumstances are not provided. So we were demanding that the court compels our government to put in place such guidance so that children can find relief when they need to. So unfortunately for us, because of the time we had spent going all over the place, we had lost a bit of time, but we hoped that the court would appreciate this as an exceptional case for them to consider. No, they said, oh, time is a creature of statute in the treaty, so we cannot expand it or use it as something, but they said this is a key issue of governance that the government of Uganda needs to take note of. But on that preliminary objection, we were thrown out of that court. But currently, as I speak, we are considering also engaging the African Committee of Experts on the Rights of the Child, because last year, once again, we received a case of a young girl. She was 14. She had an abortion. The community rose up in arms against her. She was arrested, committed to an adult prison. Spent a night there because of the uproar, of course, from human rights activists and gender people. The girl was released from prison and, granted the bond to go and receive, the post-abortion care that she needed. We find this, again, quite a bit of a problem. The harmful cultural practices. In this case, a client had an abortion of twins. And even though before the person that committed the defilement was not interested in her, when he apparently heard from the villagers that it was twins, he was interested because of the cultural norms. They wanted to commit certain kind of rituals and rites to do burial. So there was issues of mob justice for this woman, or not even woman, a child, because she's a primary school student. And then the question of abortion, criminalizing a child who has been defiled. I must note that the defiler is not in jail even as I speak. He's on the loose, running, he's free. He even had an opportunity to go and file a complaint before court and be heard, and his charge was registered. And yet, the police did not apprehend him for the defilement, but his charge of abortion was taken. This charge continues looming on this young girl who has not yet even resumed with school. So we want the commission of experts on the rights of the child to have an opportunity to interrogate issues on access to sexual reproductive health and rights services, information, sexuality information. This young girl has not had how to prevent pregnancy and all. So for me, there's a bit of tension, but also a bit of understanding when it comes in comparison to the national mechanisms as compared to the experts at the regional level. The regional level, I find them more welcoming of the discussion, whereas at the national level, we seem to be having a deadlock at the time. Thank you.
Thank you so much, Prima, for those detailed submissions, on your lived experience as counsel, as a reproductive rights advocates with Advocate WPI. And in your submission, you brought out very key issues, the issue of obstetric violence, through the denial of basic commodities, for birthing persons whenever they are for delivery. You have brought up the issue of re-entry policies for adolescent learners, be they girls, be they boys, being chased out of school or being expelled out of school for either impregnating somebody or being pregnant. Those are the lived realities of adolescents in the country. And of course, the issue of the lengthy process of litigation, but as advocates, you keep going. And I like the appreciation, that you have and how you brought out the challenges at the national level as well as at the regional level. And I would like to encourage our esteemed audience to continue interacting with our panelists by sending questions via the chat, and our panelists will be able to answer some of the questions either as they make their submissions or even on chat. So please continue to interact with the panelists, because I'm sure you've got burning questions and perhaps questions that you might not otherwise ask elsewhere. So this is the forum to ask. And having listened to East Africa, we listened to Rwanda, we listened to Kenya, we listened to Uganda. And so at this particular point, I'd like to bring in Dr. Godfrey Kagaunde from Malawi. He's a legal scholar and is published widely on matters SRHR, as well as litigated on access to safe and legal abortion for women and girls, as well as decriminalization of adolescents. And so, Dr. Kagaunde, you've listened to fellow counsel from East Africa, and I would like you to bring in a southern, perspective, as well as, your perspective as a litigator and a scholar. What are some of the biggest lessons, from Malawi's litigation experience on SRHR, and perhaps you can speak to what we can learn from Malawi as East Africans. Over to you, Dr. Kagaunde.
All right, thank you so much, Prudence. And yes, I listened to my colleagues. Thank you so much for sharing your experiences in those jurisdictions. I think in Malawi, it's more or less similar experience. But of course, we have got our specific issues. So first of all, I think if I start talking about our main advocacy push, which is for a liberal abortion law, 3 years ago or thereabouts, we put a lot of emphasis on advocating with the parliamentarians that they could maybe initiate a law reform to put in place a law that is more liberal than what we have now. But then we realized that the government was very comfortable with that approach because they had nothing to do about it, because they were waiting for the parliamentarians to put in place a law. So they were not even agitated. That is when we thought, what is it that can shake things a little bit? Then we realized that maybe we should start from the law that is there now. Because yes, much as the law is restrictive, we find that even that law which permits access to safe abortion for certain grounds, even if the ground is just life, and life can be interpreted broadly, find that abortion was virtually not available. So we changed tack, and that's when we started to engage, the third arm of the third arm of government, rather, the judiciary. And I note that in Uganda, I think Kenya, and probably Rwanda, you have been doing litigation earlier than us. I think our first case went to the court only in 2021. And it was the judicial review. So that was a milestone for us because it was the first case ever brought to the court, civil court on abortion. And this was to challenge, we framed it as challenging the decision of a health provider denying access to safe abortion for a 15-year-old girl. The case failed on technical grounds, and this is also, as we're always learning as we go along, that the health providers don't normally write in the record that you requested an abortion and I have denied it, you see? So they don't just normally tell them, verbally that you see abortion in Malawi is illegal, right? So I can't provide it, and then they don't write it they write something else in the record. So when the court looked at the record, they said, well, I don't see where the decision to deny abortion was made. So then we learned our lesson that, oh, this is how it happens in Malawi. The denial is not recorded. Now that helped us to frame our second case, because when we had our second case in 2023, something similar happened in that a 13-year-old who was raped was denied access to abortion. And the doctor just told them, well, you can't access the services. But somehow we managed to get the client, get the doctor to actually record that I have denied access to the services for this reason. And that is how we managed to do our second litigation. Right now, it is at a stage where we're waiting for the judgment. And through this, we have learned an important thing that generally the health providers, even if there is a direction from the Ministry of Health that access to safe abortion is available for pregnant, women with risky pregnancies, there's virtually no provision of that service. So for us, that is, I think, an important opportunity, because we are trying just to bring it forth to the stakeholders that, well, there is this window here where abortion should be available. Much as we would have liked that there should be a new law which liberalize it, but I think we are quite we understanding that may not be achievable in the immediate future. Maybe we should just work towards making that is what is already available accessible for women and girls. So that is what we are trying to do. And the reason really is that, well, this is just a third branch of government which should also do its work, the courts. The courts should help us to implement what the executive is already supposed to implement and interpret the law. The challenge is that the law is not straightforward, it's difficult to interpret. But yes, the third branch of government is there to do exactly that. And if there is violation, to see if we can, get redress. So, but what is then also important is that if this is something that the government is to do, then we must also be with the people. Litigation should not be just for Nyali Institute or for the lawyers who are in it. Otherwise, that is just maybe a quarter of the battle. The people the Malawians, even if there's differences of opinion, but at least we must have the people with us that this court case that is there, it's for us, it's to interpret the law for the people, not just for Nelly Institute. But then let me step back again from this one aspect, which is abortion, and just to look at generally sexual and reproductive health and rights. So as it is maybe obvious, if I might put it that way, issues of sexuality and reproduction are still contentious. I mean, when I think about it, was labor issues contentious some time back? Probably yes. Probably they were based on religion and the Bible, you know. But during the period of industrialization and everything, we managed to make this not a religious issue that should be in the hands of certain gatekeepers. It came out into the public, and then labor rights are based not on the Bible anymore, but on human rights. So I think this is also what's happening in the area of sexuality and reproduction. There is a tussle between the gatekeepers who think that this sexuality and reproduction are for us to handle. They're not in the human rights domain. And sometimes you get the feeling also, even from the legal fraternity, that these human rights issues are not as important as maybe financial laws or labor laws. But I think the thing is that this is what is most close to us. Sex and reproducing is what is closest to everybody. Even if you have got no money, you have got money, you can, if you've got money, but you are not well in the sexual and reproductive domain, you're not happy. Why then should it be something that is like looked down upon to say, oh, these issues are not very important? I think they are critically important. And when we take it from the perspective of sexual and reproductive justice, they are very interrelated with other issues, finance, justice, and how, our overall well-being. So then when I just wanted to put that, to say that then we are also working in other related areas. For instance, the current law on age of consent to sex, there's an anomaly there. In Malawi, what it says is that an adult cannot have sex with a child. Okay, yes, we want to protect children, isn't it? But then the line has been drawn so rigidly that an 18-year-old now cannot have sex with a 17-year-old because the 18-year-old is an adult and the 17-year-old is a child, So then we're saying, no, okay, we understand that we want to protect people from harmful sexual conduct, especially our children. But again, the law shouldn't just be that arbitrary, It should take into account that this 18-year-old and 17-year-old are peers. So sometimes people are like, why are you wasting all your time trying to do that? But look, there is a 19-year-old boy who has been, charged with an offense and of having sexual intercourse with a girlfriend of 17-year-old. I mean, for him, life just completely went crazy. He's in university and he had to stop university. He has to stop schooling because he was confused about what's going on. But hey, should we be taking these kind of matters to court? So that's another case that we are busy about. We'd like to try and take it to the Constitutional Court to determine the matter that look here, we do appreciate that we want to protect people from harmful sexual conduct, but then laws should also not be so rigid as to ignore the fact that there is also infringement of somebody's rights. There's also injustice in the way that the laws have been framed. And then maybe just to add another third thing, I think in Africa we say that we love, we like children. We want to have children. We like our women because they'll give us children. But how is it that we don't take care of them when they go to the hospital to give birth? Yeah. So what does it mean we're interested in the children? Yes, we want life. but the person who is facilitating, we are not taking them to, we're not assisting them in the court. So there's many cases in Malawi where women have been, humiliated, ashamed when they're giving birth, what we are now calling obstetric violence, but it's never been understood as a human rights issue. This is it's a women's issue, it's a hospital, it's a medical issue, but now we want to bring it into the public domain, that this is also a human rights issue. So when we're talking about these rights, sexual reproductive health rights, we also mean that when women come to this institution to give birth, it must be for them a good experience. It must be a quality experience. It must be governed by human rights, standards. So, I think that's what I can just say about what we are doing in Malawi right now, and be happy to engage more. Yeah.
Thank you so much, Dr. Kagaunde, for those submissions. Indeed, we are learning a lot, not only from your experience, but also from the experience of Malawi. Malawi living or experiencing a restricted environment, but still pushing, the pin to ensure that women, girls, men, boys, can enjoy reproductive rights. And I like that, you have said that in Africa, we love children, and at the same time, we're not taking care of those who bring those children into this particular world. And so again, raising the issue of obstetric violence, so much to learn from Malawi, even as we continue to litigate in Eastern Africa. And at this point, I would also like, the audience to benefit from Dr. Abiola, who is a feminist lawyer and with extensive experience in SRHR mitigation and advocacy, being a teacher of law as well as a practitioner. And Dr. Abiola, you have litigated, you have advocated for the recognition of reproductive rights as a fundamental human right in Nigeria and across Africa. And Nigeria is one of the countries that has also signed and ratified numerous international and regional treaties, including CEDAW, including Maputo Protocol. And so perhaps you can share with us, your experience as a litigator and an advocate, from Nigeria, on what are some of the challenges and successes, you've experienced, and what you can advise East African litigators working in similarly conservative environments, because you also understand the tension between colonial policies and progressive laws that have been passed in Nigeria. Over to you, Dr. Abiola.
Thank you very much, Prudence, for this gathering. I've really learned a lot from across Africa. So as I'll be speaking from the work that we've done in Nigeria, and also the current work that is going on in the country, and how we're also using the opportunity of regional instruments to litigate around sexual and reproductive rights. Though our experience recently at the African Commission, they didn't come into fruition the way we would have expected it to be. But of course, there are work going on to ensure that we respond to some of the decisions coming out from the African Commission with respect to sexual and reproductive, health rights. I would want to switch off my video because of my bandwidth. I think my network is not very good. Why I just to the issue, subject to your convenience. So, for Nigeria, the issue of sexual and reproductive rights, it's quite complex. Also given a very complex legal and policy framework. Our abortion law, for example, is one of the most restrictive in the world. The legal framework permits abortion only when the pregnant woman's life, it's at risk, which is in direct contradiction to the more progressive global recommendation on safe abortion practices, particularly from World Health Organization and other places. So, and this has put a lot of challenges on civil society and people working in this area. So we then had to look at a very creative way, using not only policy reform, law reform, to also say whether we can also litigate, to bring back the affirmation of sexual and reproductive rights of women, in the country. We have a constitution that allows for non-discrimination, and so we've actually used that as a way of holding government accountable in terms of women's ability to be able to affirm their sexual and reproductive health rights. There are a lot of issues with our health system. And of course, there are also a lot of issues in terms of implementation of, the Constitution itself, with respect to what exactly discrimination is and what it means, whether it can extend to the issue of sexual and reproductive rights. So at the courts, we have attempted to even bring the issue of maternal mortality reduction, to the courts by bringing an experience of one of the women who died while giving birth. And so rather than the courts also looking at it from the point of view of rights, or our right to life, being denied, we're surprised that the court took the turn of looking at it from a tortious, liability point of view, looking at negligence and what have you, which in itself, it's a challenge even with the judiciary in terms of their own understanding of sexual and reproductive rights and how they can help in terms of strengthening efforts around litigation to affirm the sexual and reproductive rights of women. As you may also be aware, Nigeria has one of the most porous prohibition of same-sex marriage. So there's no recognition whatsoever for LGBTQ under Nigerian law. So which also made the whole process much more complicated. But however, due to the efforts by civil society organizations and women's movement, there was some development that I think comes as a process of learning and opportunities for other countries where they have restrictive laws like what we have in Nigeria. The Lagos state, Nigeria has about 36 states, a federal state. So we have the national and also the state level laws and policies. So Lagos State had amended, the law because at that point in time we had one of the feminists leading the amendment of Lagos State. Lagos State happens to be one of the biggest populated states in country. So oftentimes what happens in Lagos affects, the rest of the country. So we had a review of the Lagos State criminal law and so amended the restrictive, abortion law in 2011 to consider situations of mental and physical health, which in a way affected some of the, is expected to have affected some of the restrictions that we have, on abortion law. But because there has also not been a lot of creative lawyering and judicial activism around it. So there are efforts to ensure that there are judicial decisions, validating that to also say that, by amending the law, what it also means is that it allows for abortion in a way. So another development that we also have, so currently there is a case that we have in court, that is asking the judiciary to take a read of that section in the Lagos criminal law to mean that women who had circumstances of rape, incest, can procure safe abortion legally. So we are currently in court challenging that. Another opening that is also there for us in Nigeria is also the the law that was passed in May, the national law. It was a national law, so it was a Violence Against Persons Prohibition Act that was passed in 2015. Had a particular section 38 that talks about comprehensive services, sexuality services, which we also felt that such section could also help in terms of, bringing the issue of abortion if you allow for women who had suffered one form of abuse or the other, to access the hospitals for comprehensive health services, that could also inform that, women would have access, to abortion in that regard. So the third intervention that has happened over time is the safe termination of pregnancy guidelines. So the Society for Obstetrician and Gynecologists of Nigeria had worked with civil society organization in this regard to come up with the safe termination of pregnancy guidelines, which is expected to be a guideline that's supposed to provide directions, for doctors to determine circumstances where a safe abortion can be legally procured. And so about 6 states across the country has been able to, adopt the safe termination of pregnancy guidelines. The guidelines actually provide a framework for healthcare providers to offer safe abortion services within the confines of the law. So this guideline, though it's not yet it's national in nature, but by the fact that Nigeria has a federal state. So when it's a national law, it only covers the Federal Capital Territory. So in other states across the country, about 6 states have also adopted the STOP, we call it STOP guidelines, Safe Termination of Pregnancy Guideline, which is a way of responding to the issue of abortion. So by and large, we are looking at the entire country taking into this, especially because Nigeria has adopted the Maputo Protocol, and other World Health Organization guidelines, and that's why we have the STOP guidelines also at the national level. So we do hope, and with the litigation that we are on, we hope that in few time to come, there should be some kind of clarification in terms of the state of abortion, safe abortion in Nigeria within the context of Nigerian law. But there seems to be a lot of opportunities that we can build upon. Thank you very much.
Thank you so much, Dr. Abiola. Indeed, again, a wealth of experience and very elucidate submissions from your end. And of course, for us to learn more about, what Nigeria is doing in terms of taking what the progressive treaties are and trying in a way to domesticate them through litigation, through advocacy, and even, advocacy at the ministerial level, engaging with ministers, with other policymakers to ensure that women can still, women and girls can still continue to enjoy SRHR services as we await amendment of the law. So thank you very much. And at this point, I would like to bring in, last but not least, Ms. Rosemary Kirui, who is a litigator working with the Center for Reproductive Rights and supporting and coordinating SRHR litigation across 7 countries. And the reason why I wanted to bring in Ms. Kirui as the last speaker for our panel today is because, again, she has experience, in these 7 countries, whether it's Tanzania, Nigeria, Uganda, Zambia, working with a lot of the partners on litigation for SRHR. And Ms. Kirui, I'd like you to speak to us about some of the SRHR barriers you've encountered across the 7 countries where the Center for Reproductive Rights works in, as well as reflect on the ASREC decision emanating from the African Committee of Experts on the Rights and Welfare of the Child that challenged the mandatory pregnancy testing and expulsion of pregnant learners from school. Ms. Kirui.
Thank you very much, Prudence. I think a number of the barriers that we have been experiencing in the countries that we work in has been actually alluded to by some of the speakers. And one of the main barriers that we see is the barrier on legal and policy frameworks. The legal environment where we have restrictive laws that criminalize some SRHR services. So as has been mentioned earlier, that most of the laws that we have were adopted or inherited from the colonialists. And most of the African countries have to date not changed the laws, so that you will find that across most of the African countries, the penal code is similar, giving a blanket criminalization of abortion, save for only when it is a surgical procedure being done to save the life of the mother. So you will find that this is being interpreted very narrowly in many African countries. And while, for instance, Kenya has changed a bit. We have reforms where we have now the Constitution of Kenya, which provides for grounds or exceptions when abortion is permitted. But however, other countries such as Tanzania, we still do not have legal reforms that have been effected. So this is one of the barriers that we are seeing. Then secondly, we see that the criminalization of SRHR services becoming such a hindrance, so that we find women and girls who probably go to seek SRHR services being harassed, arrested, and charged in court alongside with the health providers. So that this in effect creates a chilling effect, where now there's stigma around provision of SRHR services, there's stigma around even women getting abortion or post-abortion care services. And what this does is that when women and girls are not able to get safe abortion services, the service is taken under, so that a lot of women now get unsafe abortion, which raises the mortalities and morbidities from unsafe abortion. So you get to see that the mortalities are either not coming down or they are going up, because then the restriction in the law is causing the women to seek an unsafe abortion. The other issue around the restrictive laws is the age of consent, where there is a mandatory third-party requirement for adolescents seeking information and SRHR services. This is without bearing in mind the lived realities of our day and age, where we know we have child marriages, we have adolescents who are engaging in sexual conduct. The statistics show that about 15% of women aged between 15 and 19 years have been pregnant at one point. Now, the number of adolescents also engaging in sexual conduct is even much higher. So the reality is that adolescents require SRHR services, and they do not really need the consent of a mandatory third-party consent, because then that becomes a hindrance. The other barrier that we have noted is the criminalization of consensual, non-exploitative, non-coercive sexual conduct amongst adolescents. Now, you'll find, like, even for an example, like a country like Kenya or even Uganda, criminalizing sexual conduct amongst even age mates, so that you find a 16-year-old engaging in sexual conduct with a 17-year-old, and they are prosecuted in a criminal court. There are no exemptions that are given to these adolescents, yet they need protection. So when you look at these laws, it also fails to appreciate the evolving capacities of the adolescents. The other issue that we seem to face is the misinformation and disinformation, which then becomes a barrier to access to SRHR services, so that you find there are many myths being peddled. Say, for instance, if you use contraceptives, you shall not be able to conceive again. And you find a lot of women are buying into such myths, which are just really misinformation that are being peddled to the public and to the masses. Or, for instance, the myth that adolescents are not engaging in sexual conduct. So these are some of the things that we are also finding to be a barrier access to SRHR services. There is also the social, cultural, and religious norms, and I think it has been alluded to, where we have a very conservative population. And when it comes to discussion around SRHR services, you will find that the political class will most likely legislate against the woman's right to access SRHR services based on some religious or conservative inclination. It is not based on law or policy or science. So I think this is the other issue that we also see. Then we also have the issue of dwindling funding to carry out SRHR work. We all know what the landscape and looks like. We all know what happened after the Trump's election. So this is also a challenge and a barrier. And there's also an emboldened anti-rights movement where they really generally push against most of the SRHR rights that we are pushing for. The other thing that we also realize is that that we lack legal provisions for the provision of comprehensive sexuality education that is age appropriate. Up to now, most countries still experience a pushback when it comes to comprehensive sexuality education. And we need adolescents to have this information so that they are able to make informed decisions about their bodies moving forward. So I think those are some of the barriers that we see. As the center, some of the strategies that we use is one, using filing strategic impact litigation cases just to challenge the unjust laws, expand the grounds for access to SRHR services, and just get a progressive interpretation of constitutional rights. So we go to court quite often. We file cases in the national courts. We also engage with regional mechanisms such as the East African Court of Justice, the ASERWEC, the African Commission, and the African Court. As a matter of fact, I know we have a matter that ELS had filed, and we have filed an amicus in that matter before the African Court. We also do legal empowerment, where we train health providers to be able to just understand the legal frameworks on access to SRHR services within their context, and to understand their legal rights. We also do some policy and law reform advocacy just to promote and advance access to SRHR services. Maybe just to mention one litigation that we did was one that was filed before the African Committee of Experts on the Rights and Welfare of the Child. The Center for Reproductive Rights filed this case together with LHRC from Tanzania. That is the Legal and Human Rights Center of Tanzania. And this case mainly sought to challenge the discriminatory aspects from the Tanzanian government, where they expelled pregnant girls. First of all, they subjected them to mandatory pregnancy testing, and should you be found pregnant, then you would be permanently expelled from school. So CRR together with LHRC filed this case on behalf of 6 adolescent girls who had been found pregnant and were expelled from school. And the committee ruled that the practice of expelling pregnant students from school violated the adolescent girls' human rights, and recommended that Tanzania reform its education policy. So that is a decision that was given by the ASERWEC. The other thing that was very significant that the ASERWEC did was that it found the United Republic of Tanzania to be in violation of the African Charter and the rights and welfare of the child, in particular its obligation on non-discrimination and best interest of the child. So this is a very significant ruling because then it is binding on, and the charter has been ratified by at least 53 countries in Africa, so it is binding on all these countries. So the ASERWEC recommended that Tanzania first immediately prohibits the mandatory pregnancy testing and also undertakes concrete steps to prevent expulsion of pregnant and married girls from school. So these are just amongst the orders that the court gave, the committee gave, sorry. And I would encourage you to just find the communication, the decision. It is number 12 number 12 stroke COM stroke 01 of 2019, which was a very good and progressive decision because then it stopped and even made directions for the readmission of schoolgirls who had been expelled prior even to the decision. So that was a very, very, very good and progressive, and just one of the aspects of strategic impact litigation that we see really bore a lot of fruits. So thank you very much. Over to you, Prudence.
Thank you, Ms. Kirui, for those submissions. Again, very elaborate, very detailed, and our esteemed audience has gotten a chance to understand some of the barriers that our litigators and reproductive health advocates continue to deal with, and even the lived experiences of women, girls, boys and men when it comes to access to sexual reproductive health and services. So thank you very much, Ms. Kirui. And again, just to reflect a little bit on what you've mentioned about the anti-colonial policies, the anti-colonial laws that we still have. The countries represented here this afternoon still continue to grapple with those anti-colonial or rather colonial laws, and the onus is on us as reproductive health advocates to challenge these colonial policies and colonial laws and have laws that reflect our shared African identity. So thank you very much, Ms. Kirui. And so our esteemed audience, we go to a very exciting session. We do have time for Q&A, and I can see that from the chat we have a couple of questions for our esteemed panelists, and some of the questions have been responded to. Others still are live, but thank you so much to our participants who sent in their questions. Augustine, some of the questions that you've had have been responded to by Dr. Mulisa, as well as Ms. Serino Buya. Thank you so much for your questions. Ms. Vivian Etiang, those questions have also been answered by Dr. Agaunde. Sorry? Okay, so I do have a couple of questions that remain live for Ms. Minishi, and I'm just going to share them across our panelists. Ms. Minishi, there's a question here. How does Kenya reconcile the duty to respect, protect, and promote human life with the increasing liberalization of access to abortion? Then there's a question for Ms. Kwagala. How do we deal with a situation where an abortion, in the event of rape, might serve to get the rapist off the hook? Then there's a question that I will throw to Dr. Mulisa from Mr. Morrison Onyango. There's a tendency to address SRHR violations from a medical negligence angle vis-a-vis constitutional claims. And the question is, which one offers more protection or which one is advisable? So colleagues, you can keep the questions coming in. But for now, I hand over to Ms. Minishi to respond maybe in 1 or 2 minutes, and then hand it over to Ms. Kwagala. Then Ms. Kwagala will hand it over to Dr. Mulisa, and then we'll see whether there are any other questions coming in, because we are also pressed for time. Thank you. Over to you, Ms. Minishi.
Thank you, Prudence. So the question relates to the contradiction between the provisions of the Constitution as well as the, what is within the statutory laws in Kenya. And how Kenya can go about reconciling these two would be to have a legal reform or legal amendments within the statutory laws, basically, because the Constitution is the supreme law of the land, so it supersedes the statutory provisions, and it should speak to or be harmonized with the statutory laws. This would require a lot of change in social and cultural norms, so a lot of creating public awareness, countering the misinformation, disinformation that Rosemary was talking about, the last speaker, and then speaking to challenges, actual challenges and live realities of the people on the ground. So the Constitution does provide instances when safe and legal abortion is permissible, and those are instances. So ensuring enforcement and implementation of those provisions would be a key way to ensure that the people who are most affected by the denial of services or access to services then are protected by these laws. Thanks.
Over to you, Kwagala.
Oh, okay. My mic is already on.
Yeah.
I saw this comment calls for a lot of discussion, and I think this is it Augustine asks, in the face of evidence you have to prove in the face of rape, before they at least for the case of Uganda, and I know for many Commonwealth countries, the evidence of a child is not the only proof you can present for rape. In the past, medical evidence or proof of penetration was one of those that we had to do. But I know that courts, in the face of loads of advocacy around sexual violence and creation of SGBV courts to specifically look into cases, have been moving away from strictly looking at cases of penetration or proof of a pregnancy and getting DNA test, which is usually the extreme end of the evidence you have to prove, to other factors, which include mental health and the situation, or even evidence of the affected person just by observing the person as they provide the evidence. I know that courts in Uganda have severally held that women are not always more liars than men. So if the person can be believed by a judicial officer to have gone through an experience that they are translating to the court, then it is sufficient evidence to prove a case of sexual violence. So I don't believe that an abortion would bar or deter conviction, though I still agree that it might have a certain level of impact, but need not necessarily bar a judicial officer from carrying a conviction in the face of sufficient proof. If the person is there, if they can relay their experience, but also if our laws were liberalized enough to allow women to be able to decide for themselves whether or not they want to carry these pregnancies, then we wouldn't even be in this place talking. One of the objectives of this meeting was to strengthen not just partnership, but enhance knowledge of legal frameworks and strategies of how we can advance SRHR. women's well-being cannot be put at bay while we wait for laws to get along. Women will always exercise autonomy whether or not we have these laws. So we need to work harder to make it possible for them to make these cases without necessarily being subjected to stripping themselves bare for the purposes of making a point before courts of law. That's how I would respond to this, Prudence. Over to you.
Thank you so much, Prima, for that response as well. And I'd like to hand over to Dr. Mulisa for the question the question around the tendency to address SRHR violations from a medical negligence angle vis-a-vis constitutional claims, and which one offers more protection or which one is advisable. And at the same time, Dr. Mulisa, you can speak to the question around the normative content of sexual rights, for young adolescents, and whether that is contained in comprehensive sexuality education, as has been posted on the chat. And as you come in, I would also be interested to hear more of the thoughts by Dr. Kagaunde as well, his thoughts on those questions as well. Over to you, Dr. Mulisa. Tom, are you speaking? Tom, could you confirm whether you can hear us? I think you were a bit static on the screen. Okay, so as we wait for Dr. Mulisa to come in, and we'll give him an opportunity to respond, perhaps Dr. Kagaunde, you want to take that question. But I can see his mic is on. I'm not sure. Dr. Kagaunde, please.
All right. So what's the question? I see there about the normative content of sexual rights for a 13-year-old contained in comprehensive sexuality education. So if so, how do you deal with I think there is a publication posted there. I tried to look at the publication. Okay, let me just read something about the abstract. So the following topics were suggested by students: abortion, contraception, sexual rights, abstinence, STI, HIV, and preferred CSC delivery means were school-based teaching, online resources, social media, community-based elements, or trusted individuals. The students who had not received the intervention were more in favor of abstinence-only approach and demonstrated more negative attitudes towards abortion. So I haven't read the whole of it. I didn't have time. But what the article seems to be saying is that if you do provide sexuality education, then the students are most likely to not be negative towards abortion and to favor interventions that are not just abstinence only. That's what it is saying. Sorry, I couldn't read the whole article. But just to say, first of all, that when you say comprehensive sexuality education, I think the countries have different approaches towards comprehensive sexuality education. I remember the other time I was doing a little bit of an analysis. I liked, I was amused rather by what the content from Uganda, which included, I think martial arts or something like that, to be able to help the girls to say no emphatically or something like that. But in any case, the thing about what we know about comprehensive sexuality education, maybe that's what I know about that is that it enables it builds the autonomy of the young person, because when it is done appropriately, and appropriately is also maybe subjective. I can't now say that. Okay, say you want to teach the person about their body, a 13-year-old, how their body is functions, for instance, and then also how their emotions work. it will be the same kind of subject that will also be applicable even to a 5-year-old, because you want to teach her about her body, or his body, how it should not just be touched by anybody. So this is good touch, this is bad touch. So, I mean, I will not be able to put a model here on how exactly it fits, but we just know that if we are able to provide that, then it builds the autonomy of that young person. Maybe what I could add there is that sometimes there is fear of talking about sex and sexuality, fearing that the person is too young. But studies have shown that girls have eventually, who have become pregnant, have actually voiced out that, I wish my mother could have told me about this earlier. So there's those things, there's a certain fear that if I talk about sex to somebody, then they want to have it, and that makes us fear to actually give age appropriate sexual education on those subjects, just because we fear that when we do that, we're encouraging the child to engage in sex, but the evidence is saying the contrary. Actually, the evidence says that if we do, for those who we give sexuality education and in the right manner, they will actually delay sexual debut. Somewhat it's illogical the way it's said, that they will know about the sex in the education, but actually that helps them delay sexual debut. So that's how I can present this. Fortunately, I'm not able to pull out all the evidence, and put it across right here. But we can always engage further later if you do want. Yeah.
Thank you so much, Dr. Kagonde, for that particular response. Dr. Mudisa, are you back online? There's a question there on the constitutional claims.
Yes, I'm back. Yeah.
All right, thank you. Could you please respond to this question around whether framing SRHR violations from a medical negligence offers more protection, as opposed to constitutional claims? Thank you.
Yes, thank you very much. I think a few minutes ago I had some internet issues, but I hope you can hear me.
Yes, loud and clear, Dr. Mudisa, loud and clear.
Yes, I think that was a genuine question. But when you are engaging with policymakers or legislators with legal reform on sexual reproductive rights and on abortion, I think the most success has been achieved through looking at SHR violations as constitutional violations or as a constitutional right, bringing a constitutional rights issue. I was looking at a compilation of cases that have been litigated on abortion in Africa and in various jurisdictions. And I've looked at quite a number of them, special abortion. I've seen people challenging abortion restrictive laws. I've seen people using a constitutional claim or constitutional standing. I've seen people challenging forced sterilization using constitutional provisions. I've seen discrimination. I've seen discrimination in healthcare. I've seen even GBV, even reproductive body autonomy. So I think a constitutional claim or a constitutional right ground would bring a more substantive and stronger argument than relying on a medical negligence or medical malpractice argument. I think using a constitutional ground or constitutional claims and constitutional rights provides a more valid grounds when you are urging for such rights. Thank you.
Yeah, thank you so much, Dr. Mudisa, and you're indeed right. A lot of the times you've seen that tension between whether to frame SRHR violations as a medical negligence or a constitutional claim. And, our advice is always to look at the constitutions and see what it is that you can use to frame SRHR violation as a constitutional claim, as a violation of international and regional human rights treaties. So we are almost nearing the end of this webinar, but before we close it off, I would like to invite our esteemed panelists, because of time, perhaps to give closing reflection, maybe in 1 minute and a half, on what would be your call to action for the East African legal community, as well as bar associations, not only in East Africa, but across Africa when it comes to SRHR. And I'd like to start with Dr. Abiola. We'll hand it over to Ms. Kirui. Dr. Abiola, your reflection and call to action, please.
Okay, thank you very much. So it's a pleasure being here. I think that my call to action would be one, to the government of the states to obey the international instruments that the state parties have signed on to and have committed for domestication. So state parties must ensure they take all steps to ensure women's sexual and reproductive rights. I would also call on my colleagues who are lawyers for us to be much more creative in our
Dr. Abiola, we lost you for a couple of seconds there. Dr. Abiola? Okay, so as we wait for Dr. Abiola to come back online, we can hand it over to Dr. Abiola. Can you hear us? Can you hear me, Dr. Abiola? Okay, we seem to have an internet connectivity issue with Dr. Abiola's gadget. So I'd like to hand it over to Ms. Kirui for her call to action and closing reflection as we wait for Dr. Abiola to come back online. Ms. Kirui.
Thank you, Prudence. I think, sorry.
Can you hear me now?
Yes, Dr. Abiola, we can hear you now. Are you in a position to
sorry,
proceed?
let me just. Okay, can I quickly do this? So the first one is to the state parties,
Yes.
that have domesticated and adopted and ratified the Maputo Protocol and other international instruments on SRHR to ensure that it takes steps for effective implementation of the obligations therein. Then secondly, to our colleagues who are lawyers to be more creative, so that we have creative lawyering and that could help to strengthen our work on SRHR, and to the judiciary also for judicial activism that could contribute to SRHR. Thank you.
Thank you very much, Dr. Abiola. Ms. Kirui.
Thank you. I think my call to action is that the East Africa Sexual Reproductive Health Bill is important, so that we need to find ways in which this needs to pass and become law. Then secondly, that as lawyers, we leverage our expertise on litigate SRHR issues within the region. Let us share experiences, share lessons that we have learned, and even the jurisprudence, so that we are able to use cases that are progressive, jurisprudence that is progressive in our various and in different countries. So I think that would be my tip.
Yeah, thank you, Rosemary. I'd like to hand it over to Dr. Kagaunde. We'll hand it over to Ms. Prima for closing remarks as well.
Yes, I would say that I think our role should be to facilitate taking SRHR seriously. And I say this especially when I reflect on what has, what happened when Trump got into power and said, I'm going to cut funding for this. And, I was sharing with colleagues, say, okay, we are having sex here in Africa. We are producing babies here in Africa. Then we are expecting US to be sending us the condoms and, the technology to address this. I think we should encourage our governments, to take SRHR very seriously. This should be our issue, and then we should bring it to court. We should engage the parliamentarians. We should engage the executive, because this should be our issue. Shouldn't be anybody's else. Thank you.
Thank you so much, Dr. Kagaunde. Over to you, Ms. Prima, in 1.5 minutes, your closing remarks.
Thank you, Prudence. For me, it's to encourage the East African Law Society to create more opportunities of dialogue for lawyers to share experiences and lessons learned to push forward. Because as most of us were lamenting, more or less, the law is a cake. We still working with colonial systems across the board. And as, lawyers, we have a role to encourage our governments to put in place progressive mechanisms and systems to promote sexual reproductive health and rights. So I thank you, and I hope everyone has picked something that they can put to action from wherever they are. Thank you.
Thank you, Ms. Prima. I will hand it over now to Hortense. We'll hand it over to Dr. Mulisa as we close. Hortense, your call to action.
Thank you, Prudence. So I'll speak to the aspect that many of the African states have a plural legal system, and this has caused a lot of contradictions in terms of the realization to sexual and reproductive health rights. So a call to action is one, the harmonization of laws and policies, not just nationally, but also regionally. We need to speak and harmonize international legal standards with regional standards, with national standards, so that we speak and do one thing. And then aspects around creating more awareness, both for the public as well as the communities. I think many of us read the legal provisions, but then do not complete the analysis of what is provided for within our laws. And therefore, this has caused a lot of misinformation and disinformation about what the legal laws provide for, and there's need to create more awareness to counter these kinds of misinformation or disinformation that is going around about SRHR services and information. Lastly, in aspects where we do have the laws, there's a need to enforce and implement these laws, because it's one thing to have the laws, but it's useless if we have these laws, but we're not implementing or enforcing them to ensure that people are able to actually access sexual reproductive health rights. And finally, the aspect around rights is very important. I think there are many places where right now within the SRHR context, we're seeing people shying away from using rights at the end of sexual reproductive health rights. As we began this webinar, we emphasize the aspect as understanding sexual reproductive health right as a right, as a human right. And I think all of us need to ensure in our different contexts and our different networks, we are emphasizing the fact that this is actually a right that is provided for within our international frameworks, our regional frameworks, and even national frameworks. Thank you.
Thank you, Ms. Minishi. Dr. Mulisa, in 1.5 minutes, your call to action, please.
Yes, thank you very much. I think this is a point that I could have shared more, but let me use less time. In a few months, we have received MPs from Tanzania with the Civil Society Tanzania network on SHR. We received also MPs from Zimbabwe who are working on the pregnancy termination bill with the civil society organizations. But what I've understood in all those that have come to benchmark in Rwanda is that there's a need to understand the peculiarities and the specific context of each country and know how can you influence legislation in your own country. Because if KELIN and other organizations are using courts vibrant in Kenya, this may not be the same system with courts in Tanzania and Rwanda. So how does your system work? So there's a need to understand how policy changes in your country, how legislation changes in your country, who is against the legislation in the country. So if you can understand all these contexts, then you would be able to take a viable strategy and approach. Because what the people in Ethiopia did was quite contrary. They used community community-based organizations. Our community-based organizations in Rwanda were weak, but we took data and research and presented it to the parliamentarians. I don't know whether the data and research could work in Kenya. Kenyans may be having that data. What else works? So I think I heard from Hortense Minishi and I heard from Godfrey. And I think it is quite important that we understand our situation, society context, and we need also to understand how does legislation change and how does policy change? What works in our own jurisdictions and contexts? I think this would be something very good because the parliamentarians in Zimbabwe told the civil society members that had come together that we have not seen a good working together of civil society with institutions in charge. The parliamentarians from Tanzania who came with civil society here also told something to the civil society. South Sudan team that was here, which led to all this process, had a discussion with so they should be understanding the context, and so that we know which tools we should employ. But lastly, we need support from the law society, the South African Law Society, that we need some more work at the EAC level. We are doing a lot at the national level, but we need to see some more engagement at the EAC level, at least to see if it can trickle down. Thank you very much.
Thank you so much, Dr. Mulisa and our dear esteemed panelists. We have come to the close of our webinar this evening. And just to say a big thank you to all who joined us out of your busy schedules and those who have engaged with us on chat, on Q&A, as well as for taking time to listen. And I do believe we all have a shared understanding of the challenges that we deal with as women and girls, men and boys, reproductive health advocates, as well as litigators. And I do believe as bar associations, we've learned a lot from our colleagues in Nigeria, in Malawi, as well as listening to the lived realities of our colleagues in Rwanda, in Kenya, in Uganda, in Tanzania, on what we can do to advance reproductive health and rights. And as Dr. Kagaunda said, we are reproductive rights because we live and breathe reproductive rights every day. And to the leadership of the East African Law Society and to the leadership of the Center for Reproductive Rights, we are truly grateful for having given us this opportunity to engage. And I do wish you all a lovely evening, afternoon, morning, whatever you are. Thank you so much. Goodbye.
Thank you, Prudence, and our dear esteemed panelists for that very wonderful conversation. And yeah, picking up from where Dr. Mulisa hinted, there is a need to have more work done regionally, and that is something that the East Africa Law Society and the Center for Reproductive Rights will work hand in hand to ensure that we push the bill that has since stalled at the region, but also we shall continue to conduct initiatives jointly that could also include some physical trainings. But on behalf of the entire team, on behalf of my CEO, Mr. David Sigano, I would like to sincerely thank you, esteemed panelists and participants, for engaging with us for 2 hours now. It's been thought-provoking, it's been inspiring, and it's been really it's a good session for us to have a reflection on. Special thanks to Mr. Martin Onyango, the team lead at the Center, for allowing us to do this jointly. We'll be bringing you more of these sessions within the course of the year. Please look out for a subsequent session on sexual reproductive health rights. I'm excited at our next topic, and we'll be discussing this ostensibly in the month of August. So from us at the Secretariat, we urge you to continue supporting us and look towards our next webinar on Thursday this week. We'll be discussing mastering construction disputes, and we have an esteemed panel of experts in construction law. We also urge you to be on the lookout for our in-house council convention that will be happening on the 28th and 29th of August in Kigali, Rwanda. Otherwise, from us to you, we wish you a very lovely afternoon. You stay safe until we meet again. Goodbye. A recording of this session will be shared on your emails, and we'll take the conversation forward. Be blessed, and we'll meet again. Thank you.
Thank you. Goodbye.